Introduction. Have you ever heard of continuing detention orders or extended supervision orders? These are extraordinary powers used by governments to detain or control individuals for crimes they haven't yet committed. However, new information has just been revealed casting doubt on the way this tool is being used. In today's video, we'll take a look at the damning report that's been uncovered and how it could impact those affected. Part 1. Legal aid lawyers and their clients were unaware of a government-held report which critiques the tool used to lock up or control 25 of their clients on the basis they might commit a terrorist offense in the future. But now Guardian Australia has exposed the reality of the way the federal and New South Wales governments have wielded these tremendous powers. The powers are rooted in a tool utilized to evaluate an individual's likelihood of future terror offending, known as the VERA-2R assessment tool. Part 2. It all began back in May 2020 when the then Morrison government commissioned an academic expert, Dr. Emily Corner, to write up a report. At taxpayer expense, Dr. Corner came back with a report that was quite damning about the tool's use. As the report states, the lack of evidence underlying the tool has serious implications for its validity and reliability. Despite this, the Commonwealth sat on the report and continued to use the tool for detaining or monitoring offenders. Part 3. It wasn't until 2.5 years later, during an inquiry from the independent National Security Law Monitor, INSLM, that the report was revealed. It seems the report was never shared with defendants, including Legal Aid NSW, at any point during 25 separate cases involving their clients. Legal Aid NSW became first aware of the report when it was referred to in the HSLM hearing in November 2022. Part 4. In response to the report's damning findings, the INSLM has recommended the abolishment of continuing detention orders and an overhaul of extended supervision orders. Legal Aid has expressed support of those recommendations. Regarding the Commonwealth's failure to share the report, they stated they would only release it if Legal Aid made an undertaking not to share it any further. Part 5. Lawyers who represented individuals who were targeted with these powers have expressed outrage. The Victorian Supreme Court has even questioned the federal government on their handling of the Corner report. As for the NSW government, they declined to answer questions about their current use of the tool and when they first became aware of the report. However, they did state that they don't rely solely on a single assessment tool when containing or controlling terror risks. Conclusion. While the situation with the lack of disclosure surrounding the VERA-2R assessment tool is troubling, at least the issue has been brought to light and steps are being taken to address it. It's important to remain vigilant so that civil liberties are not infringed upon.